Hello everyone. We are back for the second session of UPSC Prelims 2026, 360 plus high probability topics of deep revision. In the last session, we have started with polity and we have done about half of polity revision. We'll try to complete it in this session. So, regarding us, we are Sthitpragya Learning Community. You can connect with us on Telegram on this channel, UPSC with Professor X. You can mail me on sthitpragya@gmail.com. And of course, subscribe to this channel. Go through the other videos on this channel. You would gain a lot from the conversations which we have had, from the things which I have shared. And of course, do like and share this video. Share it with all your friends and with serious aspirants so that they also get confidence that they have prepared in the right manner. And in the last few days of the examination, confidence is all that matters. So let's proceed. In the last session, we have done 130th, 131st constitutional amendments. We have seen through different constitutional amendments too. We have seen governor's role, election commission and electoral reforms, parliament's powers and privileges, and right to vote, representations of people act, federalism, center-state relations. Let's start with judiciary today. So what are the key doctrines and 2024-2025 judgments which have come by the judiciary, mainly Supreme Court and High Court? Subclassification within SC/ST reservations has been upheld by a 7-judge Supreme Court bench on August 2024. States can now create subcategories within the SC/ST for reservation. It overrules E.V. Chinnaiah case of 2004. Creamy layer concept may apply to SC/ST by the majority opinion of the SC bench. Electoral bonds were struck down by SC 5-judge bench, which we saw in the last electoral reforms PPT also. It was done on February 2024. It violated Article 19(1)A, which is right to information, and Article 14, which is right to equality. Political funding anonymity was declared unconstitutional and ordered disclosure to ECI and SBI within 3 weeks because the electoral bonds were taken by SBI, mandated by the ECI for different political parties. Rupees 16,518 crore bonds were sold between 2018 to 2024. Aligarh Muslim University minority status, 7-judge bench in November 2024, by its verdict of 4:3, it reversed S. Aziz Basha judgment of 1967. It held that AMU can claim minority institution status under Article 30. Minority, so Article 30, Article 29, they both become very important in claiming what is the minority character test, and you can create educational institutions based upon art, culture, and minority, protecting minority linguistics. So go through these two articles in detail, go through the wordings of Article 29, because again, in different PYQs, UPSC has tried to understand whether we can distinguish between protecting the linguistics and art and culture of minorities with religious instruction or not. Right to privacy, Puttuswamy case of 2017, very important case, 9-judge bench, which held the privacy as fundamental right under the articles 14, 19, and 21. It is foundational for data protection laws. In fact, the Data Protection and Data Privacy Act of 2023 builds upon this case of Puttuswamy 2017. Basic structure and judicial review, Article 32, remedy for fundamental rights itself. It cannot be suspended during except emergency. So Article 32 is called the heart of the Constitution by our Constitution makers themselves. Why? Because it provides remedy if our fundamental rights are not being honored. Then what can a common citizen do? And it cannot be suspended except under emergency. Article 226 gives the power for High Court writ jurisdiction, which is much wider than Supreme Court. This is very important to note, one of the nuances which is a part of static, which every new aspirant should know. Article 13 we generally ignore, but one should go through the language of this article because it declares the pre-constitutional laws void if they had some inconsistency with the Constitution. National Judicial Appointments Commission NJSC judgment of 2015 struck down the 99th Constitutional Amendment Act and it restored collegium. Collegium consists of CGI plus 4 senior judges. It is responsible for transfers and appointments for the senior Supreme Court and High Court judges. It is still controversial. Law Commission to 277th report of 2023 recommended reforming collegium with more transparency. So the judicial reforms, what are the key themes here? One is, of course, the independence of judiciary, which is NJSE, right to privacy, DPDP Act from the Puttuswamy case, electoral bonds being struck down, upholding the right to information and transparency in the electoral process of the country, subclassification of SC/ST reservations, might be the introduction of creamy layer concept, then protection of minority institutions for their art, culture, and linguistics, and of course, upholding the basic structure and judicial review doctrine, Article 32, Article 226, and Article 13 becoming very important for that. Let's move forward. Now, we had questions regarding Lokpal in 2025, so it's always very important that we read about accountability bodies, the bodies which keep the entire nation accountable. So there is a service called Indian Audit and Account Service. Then there are various account services like Indian Defense Account Service, Indian Civil Account Service. These bodies act as accountability mechanisms within the entire bureaucratic and executive structure of the India. Lokpal being one of them, which is the highest body for accountability against corruption in the country. And CAG is the bulwark of financial propriety in our country, which we again read through our static knowledge. Lokpal and Lokayuktas Act 2013, chairperson can be a former CJI, a Supreme Court judge, or an eminent person. It is mainly for anti-corruption. And it has 8 members, of which 50% should be judicial. The jurisdiction actually covers the Prime Minister with safeguards. National security, atomic energy, space, and external affairs are excluded from these. So, very important point, Lokpal and Lokayuktas do cover the Prime Minister, but it excludes a few items like national security, atomic energy, and space and external affairs. 2/3 of the bench is required to be in sync to cover Prime Minister as the jurisdiction. Inquiry against the sitting PM can be done by the full bench. All 9 members should be involved, which is the chairperson plus the 8 members. And all of them must agree to initiate the inquiry against the PM. Only then the proceedings can be held. And proceedings are held in camera. No action can be taken without 2/3 of the approval of the 9 members. Basically, it requires 6 members approval for action to be taken against the PM. So it gives substantial insulation to the PM versus ordinary public servants. Lokayuktas became mandatory under the 2013 Act for all states within 1 year. But there was no uniform structure which was prescribed. Each state has its own legislation. Some states like UP, Bihar have created Lokayuktas with wider powers than center's Lokpal. It's very important to know that Lokayuktas were made mandatory if any option like that comes, but there was no uniform structure prescribed. So each state has their own legislation for creating these Lokayuktas. Some states have taken the step of widening the power of these Lokayuktas as defined in the Act. CAG, Article 148, very important, 148 to 150, relates to the powers of Comptroller and Auditor General of the country. It is the guardian of the public purse. It submits 3 types of reports, very important. 3 types of reports are general, finance or performance and efficiency audit. In general, you have appropriation audits too. These reports go to Public Accounts Committee, which is a committee of Lok Sabha and Committee of Parliamentary Affairs. CAG reports on public enterprises, government companies also are published separately. So there are 3 very important reports by CAG, which are related to appropriation, finance, performance, and efficiency, which go to PAC, Public Accounts Committee, and Committee on Parliamentary Affairs. And CAG also publishes a 4th report, which is on public enterprises, which are government companies separately. Public Accounts Committee is the oldest parliamentary committee, which was established in 1921. It has 22 members, 15 Lok Sabha and 7 Rajya Sabha members by convention. It is chaired by the opposition leader in Lok Sabha. So very important part, Public Accounts Committee is is one of the committees where one of the most important committees of Parliament, where even the CAG submits their reports, and it is chaired by the opposition leader so that it can keep the government, or it can hold the government to account for its spending and other measures. It examines CAG reports. It cannot question policy but can examine implementation. So it is also called post-mortem committee in that regard, where what policy is being made, it cannot question it, but how is it implemented and what are the results, it can of course question on the basis of the CAG reports. Then we have the RTI Act of 2005, where information was to be given within 30 days, 48 hours for life and liberty. Let me tell you, as an officer, when I was serving, RTI Act is one of the bulwarks of current day, modern day administration, because whenever citizen files an RTI, it becomes the responsibility of the entire government machinery to answer that with the most appropriate and the most holistic information that is present with the department, and they cannot hold it back. This leads to a lot of transparent governance. Chief Information Commissioner, which is at the center, and State Information Commissioners are the mechanism through which this act is executed. Exemptions under Section 8 are given on the basis of sovereignty, strategic uses, commercial confidence, fiduciary duties, cabinet papers, and personal privacy. So, like we saw here in the Lokayukta case, where jurisdiction was covering the PM, but there were certain exceptions. Similarly, we have exceptions under the RTI Act 2, where if you would file an RTI, then the government body may claim exception on the grounds for some questions regarding sovereignty, strategic protection, commercial confidence, fiduciary duty, cabinet papers, and personal privacy. Section 4 of RTI Act also leads to proactive disclosure. So a government agency, in fact, there are many good administrative examples in which few civil servants have taken the mantle of giving proactive disclosures regarding their work and implementation and their departments. So these topics again fall under the category of evergreen plus PYQ, and they're also always in news in some way or the other. Let's go on to anti-defection law and 10th schedule. Again, it has been in current affairs a lot in different ways. And this is one of the favorite topics of UPSC, in which UPSC can ask you about the concepts, about the various laws. It can even ask or go deeper into the different laws, connect it with various current events, and see what actions were taken by different functionaries. 52nd Constitutional Amendment Act, again a very important CAA to be remembered in 1985, which is related to anti-defection law, which added the 10th schedule in our constitution. So 52nd CAA 1985, important, 10th schedule, very important, related to anti-defection law. 91st CAA 2003 abolished split provision, which is 1/3 defection. It only led to merger. That is, if greater than 2/3 members join the party, another party. And it happened very recently when a few members of AAP joined BJP, which was a merger because more than 2/3 or 2/3 of the MPs joined BJP. So why was it important? Because 91st Constitutional Amendment Act made it mandatory that a split cannot happen. Only a merger can happen, which requires more than or equal to 2/3 of the members of one party to join another party. And then the merged party is accepted by legislature party's wing. What is the ground for disqualification under the anti-defection law and 10th schedule? It is one, voluntarily giving up party's membership. It also includes anti-party activities as per Supreme Court. So if one voluntarily says that I do not want to be a part of this party, and also they have been involved in anti-party activities according to Supreme Court, that is one of the grounds for disqualification. Another is voting and abstaining against party whip without prior permission and without condoning within 15 days. That is, party whip had laid out one instruction that we had to vote on an issue in a certain way, but if a candidate goes against it or abstains from voting for it and also does not explain the reason to the party whip within 15 days, then these are grounds for disqualification of that candidate from the party. What are the exceptions? Well, if you're taking part in the election as a speaker or a deputy speaker, they may resign from the party till the time they are speaker or deputy speaker. Or if there is a merger, or if there is an expelled member who is not automatically disqualified, because there is a distinction which is being made between the party and the legislature party. Well, this is a very important concept, not necessarily directly that UPSC will ask from it, but one should understand that There can be a few exceptional cases where an expelled member is also taken as exception and he is allowed to vote because he might be expelled from the political party, but the legislative party he is a member of. That is, he is not been expelled from that legislative party. And of course, speaker and deputy speaker, they can resign from the party for the tenure for which they are uh, holding that office. Now, the speaker decides in anti-defection law, which is subject to judicial review. For example, we had the Kyoto Holohan case in 1992. They must decide within reasonable time. So we have seen that now the Supreme Court has been very strict in defining the timelines for various things, be it reserving the bills, which we saw in the previous slides or the previous video also. Supreme Court has given a time of specified time of 1 month for the speaker and 3 months, 1 month for the governor and 3 months for the president to decide upon a bill. Similarly, Supreme Court in the Kyoto Holohan case has said that the speaker must decide within reasonable time on the anti-defection law whether certain MLAs or MPs needs to be disqualified or not. And also there is another very important case, which is Keisham Meghachandra case of 2020, where Supreme Court directed 3 month deadline. Speaker cannot differ indefinitely. So we have deadlines given by the Supreme Court. Mostly it is 3 months for anti-defection law. What is the manipulation trap? Majority members elect new speaker. So speaker dismisses dissenting minority, which was used in Maharashtra and Telangana. So again, Nabam Rabia case, which we saw, which was very important related to governor's powers also. It bars the speaker from deciding when removal motion is pending. That is, if there's a dismissing motion against the speaker itself, then the speaker cannot decide whether the removal motion again and on anti-defection law against some MPs or MLAs should go ahead or not. Supreme Court in 2023 in Subhash Desai case, 5-judge bench said that speaker's decisions on the 10th schedule should be referred to a tribunal or made time-bound. It referred to a 7-judge constitutional bench decision pending as of 2026. So you can see that the Supreme Court is trying to actively or proactively make sure that there are no loopholes left in the 10th schedule and the anti-defection law through which different political parties can delay the decisions taken for declaring whether a party or a member is disqualified or not. And what are the important cases? Nabam Rabia case, Subhash Desai case of 2023, Kesham Meghachandra case, which decided on the 3 month deadline, and of course the Kyoto Holohan case of 1992, which says that the speaker is subject to judicial review in the anti-defection law, the decision of the speaker. Let's move forward. Constitutional bodies and statutory bodies, PYQs, extremely high frequency PYQs, and of course they are evergreen. So what are the different constitutional bodies which are created by Constitution? One should absolutely remember it along with the articles. Read these articles in detail, make notes of them. What are the keywords given? What are the powers given to them? CAG from Article 148, Article 148 to 150 relates to CAG. Then we have Attorney General, which is Article 76 at the center. We have Election Commission of India. Similarly, we also have Advocate Generals similar to Attorney General for states, which are constitutional bodies. Then we have Election Commission of India in Article 324, Finance Commission, Article 280. We have read about Finance Commission in the previous video. UPSC 315. In fact, 16th Finance Commission has been awarded. Dr. Arvind Panagadia is the head of 16th Finance Commission. Go through its TORs. Also go through the TORs of 15th Finance Commission. UPSC and state PSCs as constitutional bodies in Article 315. Interstate Council in Article 263. Again, we have read about it. Zonal councils as statutory bodies. Then there are national commissions for SC, ST, and OBC in Articles 338, 338A, and Article 340. They cannot be abolished by ordinary law. So these are the constitutional bodies. There would be some parallel bodies on state which would also have their own articles. Go through them. Apart from these bodies, all the other bodies are statutory bodies. That is, they have been either statutory bodies or executive bodies. That is, they have either been established by some law or by some executive action. What are the statutory bodies? Important ones created by Acts of Parliament. One is CBI, which derives its power from DCPE Act of 1946. Then, in fact, the UPSC has asked about this DSPE Act of 1946 and CBI. Then CVC through the Act of 2003, Lokpal, we have already read it in the previous slide. Then we have NHRC, which was through PHRA Act of 1993, CIC, RTI Act 2005, NCPCR again by a statutory body by an act, SEBI by an act in 1992, and RBI, a pre-independence act of 1934, which is by named RBI Act. It can be abolished and modified by the Parliament. What are the executive bodies for which there is no act, but they have been formed by executive order? They are Niti Aayog, which is a think tank or an advisory body to the central government. We have the National Security Council, which looks after our most important or pressing security issues apart from the Cabinet Committee on Security. We have PM's Economic Advisory Council, Planning Commission, which is now defunct, and it can be created and dissolved by the cabinet without parliament, these executive bodies. So very important to make distinction. You need to remember all the constitutional bodies and the articles. Then you need to remember the important statutory bodies along with the acts through which they were created, and also go into some amount of details for these acts regarding who are the functionaries, who can be appointed, the head of these bodies, what should be the qualifications for that, who can be the members, what are the qualifications for the members, what are the ages for those members, what are the different powers or functions of these bodies, and if there are any exceptions or not. NHRC is a very important body. The chairperson can be a retired CJI, Chief Justice of India. It has 5 members and it can only recommend compensation, not enforce. So it has recommendatory powers and not enforcing powers. It cannot investigate armed forces complaints. It can only send to the government, and it can investigate ministries for negligence. So very important to know about the powers of NHRC. It is a recommendatory body, not an enforcing body, and it cannot investigate armed forces complaints, but it can investigate ministries for their negligence. CBI has no statutory basis in central law. That is, there is no specific CBI Act, but it derives powers from DSPE Act 1946. So go through DSPE Act, and central government can notify offences in this act. But very important, state consent is required to operate in any state except for CBI courts. So this distinction is very important. That is, CBI derives its power from DSPE Act, no separate act for CBI. Central government is notifying offences here, but state consent is required to operate in any state. Apart or only exception is CBI courts. It has also gone through the criticism of caged parrot by Guwahati High Court in 2013. Another very important body which was established for internal security, that is National Investigation Agency through NIA Act of 2008. It is a central agency for terror cases similar to FBI in USA. It can take up cases suo moto, very important. So NIA can actually take up cases suo moto for internal security after 2019 amendment. So it was not in the original act, but after 2019 amendment, they can take suo moto cases, and state police must hand over these cases when NIA takes cognizance. Concurrent jurisdiction with the state police. So NIA has concurrent jurisdiction with the state police, but when NIA takes cognizance, the state police has to hand over those cases to NIA. Very important, do go through these slides, do go through these bodies, go through these acts in some amount of detail and understand these bodies and their functioning. Let's go on to one of the very important topics in current affairs, which is Census 2027 and delimitation. Census 2027 was announced in October 2025. First census since 2011. It was delayed by 6 years due to various reasons like COVID and political reasons. The reference date for the publication of census is 1st March 2027. It is the first census which is happening on mobile app, and it is a digital and self-enumeration option also. So basically, census is again done every 10 years. It started from 1881. Go through the details of census, of how many censuses happened, how many happened pre-independence, what were the different features of each census, which census were special, either done pre-independence or post-independence, what were the different population matrix, and how our country has progressed in terms of population and other indicators which is enumerated by the census. So go through the entire history of census, understand the mechanism of census, what are the bodies which conduct the census. It is done by Ministry of Home Affairs, who is the major body or registrar general which conducts these census. These are the things which you should know as part of the static. Caste enumeration was done for the first time since 1931. Socioeconomic caste census 2011 was incomplete and it was not officially used. So OBC data, caste data is critical for subcategorization post 2024 SC ruling. So SC has ruled that OBC data subcategorization has to be done, and this census tries to do that for the first time in a great detail. Article 82, which is related to delimitation, it mandates the readjustment of Lok Sabha seats after every census. Current allocation was frozen since 1976 amendment, which was based on the 1971 census. Now it has been extended to 2026 by the 84th Constitutional Amendment 2001. The 131st Constitutional Amendment Bill, it proposes delinking the census from the process of delimitation so that the southern states are not penalized for having better population control measures. Southern states' concerns were states with better population control, Tamil Nadu, Kerala, AP, Karnataka, will lose seats related to UP, Bihar after delimitation, which violates the principle of rewarding demographic discipline. So there is a tussle between one person, one vote, and being demographically disciplined and taking good measures for population control. And hence, the population or the census has been delinked with delimitation, which we have read about in the previous video also in detail. Go through Article 82 regarding this and go through this debate which is happening in the Parliament regarding 131st Constitutional Amendment Bill. The 16th Financial Commission, which we have read in previous video, will use the 2011 census data itself, because till the time its TOR come out and its recommendations come out, the 2027 census might not be ready. 15th Finance Commission already used 2011 data. So the population criteria, which is 15% of weight, will shift northward after 2027 data is made available. Women's reservation, we have read in detail 106th Constitutional Amendment Act in Nari Shakti Vandan Adhiniyam in the previous video. Expressly conditioned on census plus delimitation, it cannot be implemented until these are done. So this women's reservation can only be applied 33% on Lok Sabha, that is the seats of parliament, as well as state legislative assembly, Lok Sabha, Rajya Sabha, and the state legislative assemblies. It is based on census plus delimitation, and it cannot be implemented unless both of them are done. And hence the earliest they can be implemented is 2029 elections if census is completed on time and delimitation is completed by 2028. So this is a very important topic related to current affairs. Again, keep in mind, go through the entire history of census, which body conducts it, which ministry conducts it, how many census has been done till now. In fact, go to the exact number. This can also be asked by UPSC, that how many census has been done, which was the first census, how our population has progressed. So economy and polity can be mixed together to create questions this time based upon census and delimitation. Then we come on to our last topic, which is fundamental rights, Article 12 to Article 35. Again, they are evergreen topics, as well as there are multiple PYQs in this duration of 2018 to 2025. Article 12 gives the definition of the state. There has been PYQs regarding it. So what is a state? It is government plus parliament plus state governments plus local bodies plus other authorities also, which the Supreme Court expanded via cases. So ONGC, LIC are part of these other authorities in the state definition. There was a case also regarding BCCI, but it was held that it is not state in 2022. What is the test whether any body is a state, part of the state or not? That is, it should have pervasive state control, plus it should have a public function. And hence, PSUs like ONGC and LIC become part of the state, because not only do they have pervasive state control, but they also have a public function. So this is the definition of the state. By heart it, go through the Article 12 of the Constitution in detail. Article 13 is also something which generally people ignore. Go through it, the exact wordings in the Constitution. It declares that pre-constitutional laws are void due to the extent of inconsistency with Part 3, which is the fundamental rights. Post-constitutional laws are void if they are also inconsistent with the Constitution. It does not apply to constitutional amendments like in Golaknath 1967, but it was then overruled by the basic structure doctrine in case of Nandan Bharti case of 1973, where it was stated that basic structure is limited by amendments. Article 19 has different kinds of freedoms. There are 6 rights which are given. Originally, there were 7 rights, but the last right to property, was deleted by 44th Constitutional Amendment 1978, and now right to property has become a legal right. So very important, go through the 42nd and 44th Constitutional Amendments. It has, so Article 19 also has reasonable restrictions, which is stated in Article 19(2)(6), and Schedule 9 laws, which are related to land reforms, etc., get partial immunity from Article 13. Iyer Coelho case in 2007 said that Supreme Court can review even Schedule 9 laws for basic structure. So this is very important. Article 19, you should go through it, each and every sub part of this article in detail, because there are various terms like reasonable restriction, uh, defamation, etc., which UPSC has asked in PYQs. You should also understand that 44th CAA, what was the right to property, uh, like it was made from a constitutional right to a legal right, and what is Schedule 9, which is related to land reforms law, which was again brought under judicial review by Supreme Court under the IR Coelho case. Article 20 and 21 are in fact, Article 20 is very interesting. 22 is also very interesting. 20 protects against self-incrimination. It is only for accused and not witnesses, which was stated in the Nandini Satpathy case in 1978. It has various protections. For example, protection against double jeopardy. That is, for the same offense and same facts, you cannot be punished twice, and it leads to no ex post facto conviction, which is you cannot be given enhanced punishment. So in Article 20, it protects the rights of the accused against double jeopardy and post facto conviction. Article 21A, which was added through 86th Constitutional Amendment Act of 2002, which leads to free and compulsory education for children between 6 to 14 years. The RTE Act of 2009 implements the 86th CAA and Article 21A. It was extended to 3 to 6-year-olds by 2019 Constitutional Amendment. And private schools must hold 1/4 of their seats for EWS quota. This is a very important part of the RTE, Right to Education Act. Article 32 versus Article 226. Well, Supreme Court can give different writs like habeas corpus, mandamus, prohibition, certiorari, and quo warranto. I hope that everybody goes through these definitions in details, because UPSC has asked these terms in various ways. They have asked their definitions, they have asked match the column, they have asked different cases, and then asked which term it would fall under, whether habeas corpus or mandamus, prohibition. So you need to understand it conceptually. And this is only for fundamental right violations, Article 32. The High Court writs for any legal right plus fundamental rights plus wider territorial jurisdiction. That is why we say that Article 226 has much wider jurisdiction. That is, High Courts have much wider jurisdiction in their writs as compared to Supreme Courts, because Supreme Court only covers fundamental rights, while High Court writs covers legal right as well as fundamental rights and wider territorial jurisdiction. Article 32 itself is a fundamental right, and it cannot be suspended except during emergency, which is given in Article 359. So this is another very important article which we generally miss. So go through and read Article 359 in detail. With this, folks, we come to the end of polity revision, deep revision of high probability topics. In the next sessions, we'll go to other subjects. So see you in next sessions. Thank you.